Thank you. Please be seated. Good morning. This is the time for oral argument in case number 1, CACV 19-0543, Aerial Funding LLC, Plaintiff Appellee versus Michael A. Van Sickle, Defendant Appellant. Counsel, just a couple of reminders that if you because we are recording this oral argument on video and audio, if you'd please give your name and who you represent at the beginning of your arguments. Each of you will have 20 minutes in which to present your comments. Appellant's counsel, if you'll watch the clock and retain as much time as you'd like for rebuttal. After Mr. Abney presents his argument, if you'll give us just a minute to wipe down the podium for you, that would be nice, and then allow you to proceed. And then if you do the same for rebuttal, just want to make sure everything is as clean and as possible. So also please keep in mind, I'm sure you're aware that we've read the briefs and discussed this in conference, so we're very familiar with the basic facts. But with that, Mr. Abney, you may proceed.
May it please the court, my name is David Abney, representing the appellant Mike Van Sickle. I think, well, the main issue, I believe, and it takes care of the whole case, is whether there can be waiver of ARS section 33814G. If there can't be waiver, then I'm okay. If not, I need to get into other arguments beside that. But the language is very strong. It says that no action may be maintained. It's a prohibition against the lender or the holder of the obligation from bringing a deficiency action in the first place. Case after case, Arizona courts have said there can be no waiver. The lender cannot waive it, the provisions, the borrower cannot waive it. And it was not brought up, I don't know why, at the trial court. I think that the lawyer for Mr. Van Sickle was so focused on the proceeding, the unusual proceeding that they were going to be going through, where you're going to show up and talk about a deficiency and not be able to put any proof on it, which the trial judge referred to several times as being unusual, which is putting it mildly. I've never seen anything like it. You show up at a hearing, you don't get to say anything, really, of any substance. But if you accept the proposition that ARS section 33814G applies and it cannot be waived even here at the appellate level, then I win. My client wins, and we can pack up our tents and go home.
Let me ask you what waiver is. Of course, you've probably heard this definition many times, but courts generally define waiver as an intentional relinquishment of a known right. How did your client not know he was giving up this right when it was clearly this occurred after a lot of water had run under the bridge already? A lot of things had happened. So we're not talking about the situation where the mortgage broker slides the documents, or the title company slides the documents across the desk that thick, and you're supposed to sign all those, and you right. See those. Didn't he know very well what he was signing?
I don't think he knew very well what he was signing. I don't think anybody reading that settlement agreement would know very well what they were signing. It's to me, looking at it independently after.
But he had counsel.
Well, I know he had counsel, and looking at it, it looks like a waiver agreement to me, but the word waiver or waive and no variation of that appears anywhere in it, which is very odd. I think that the holder of the obligation understood that there could be no waiver and didn't want to get waiver in there. Wanted to go the side door to try to get the same result as having a waiver. And the side door was to say, well, if we do have a deficiency action, if you do not fulfill the obligations of the settlement agreement, then there can be this deficiency proceeding, but you can't defend against it.
Wait, are you saying that they knew what an anti-deficiency statute was? They knew they were giving up the rights under an anti-deficiency statute, but it didn't say waiver? That changed the rubric? That changed the game?
Well, there can be no waiver, is my position. Under the case law and under the terms of the statute, there can be no waiver, period, no matter how you try to do it. But what they tried to do was to say, to produce a document that doesn't have waiver in it anywhere. And yet it gets the exact same result. And I don't think you can do by the side door what you can't do coming in the front door. And then coming in the front door, you cannot have a waiver. Now, I don't understand what the thinking of Mr. Van Sickle and his counsel. I don't know if they were that if he was so flummoxed by being in this precarious financial situation or not. Why they would go this way, I have no idea. But the end result is that you cannot have a deficiency proceeding. And the statute's very clear. No action may be maintained. No action may be maintained. That's what the trial judge, and the trial judge was, you could tell he was uncomfortable with what was going on, but unfortunately nobody pointed out to him. The other side wasn't pointing out to him, like Mr. Van Sickle and his attorney were so confused or bamboozled or whatever that they didn't point out either. But there cannot be a waiver. And if there cannot be a waiver at any stage, and I submit to you there cannot under the case law, then this deficiency action was improper. There can be no deficiency judgment, which is now massive. It's the last firm count I had of it was 322,000 plus, and it's been going up and up and up at 8% and some odd per year.
Counsel, isn't there some wiggle room, perhaps, under the loop? I'll call it the loop 101 loop 101 of case. The Supreme Court had stated this, and I think this was with regard specifically to the waiver of the fair market value determination.
Subpart A.
And they said our Supreme Court has recognized that though some statutory rights may not be waived prospectively, a party may still forego enforcing them in litigation. Well, sure. Isn't that exactly what we have here? Well,
it's different wording. The 33814A is not a mandatory. This is you may do this or you may not. It's up to you. Well, if you want to ask for this determination of fair market value, here's how you do it. If you want to do it. If you don't want to do it and you don't do it, then you can waive it. That is something that's waivable. But the 33814G is not something you can waive.
You're saying never. It just can't happen. That's your position. You just can't. It's black and white.
This is.
Right? Yeah.
If the question is the subpart G black and white, is that the question?
Yeah.
Yes.
I mean, it can never be waived under any circumstances.
Never.
That's right.
It's absolutely black and white. And it's not designed. There's a footnote in one of the cases. Parkway Bank and Trust, footnote 4. A very nice discussion of when you can waive statutes and when you cannot. And the reason you cannot waive the 814G is it's not designed just to protect Mike Van Sickle. It's designed to protect all borrowers across the state of Arizona. This is a public benefit being conferred, and you cannot waive it. Very strong, very clear language.
Let's say we either A, we decline to address this because it wasn't raised, or B, we disagree with you. Then I'd like to explore your position on the fair market value hearing. I mean, and why you think the court erred in not holding that hearing.
Well, there was a specific request for it, a separate document, which I printed out in the wee hours last night, and if I can find it here. Oh, yeah, here it is. Index of record number 60, defendant's application for fair market value determination. So index of record 60, there was a formal request before this deficiency hearing for this fair market value determination. There was no waiver of that. I looked at the
agreement,
oddball settlement agreement doesn't seem to waive that at all. It doesn't say anything about the fair market value determination, your right to request and not request. So there's been no waiver of that. And they asked for it, but the trial judge didn't do it. The trial judge should have done it. If he had done it, then that would be a second level of protection. If for some reason the G one flies out the window, which I hope it doesn't, but if it does, then the A provides a second level of protection. I put in.
I didn't mean to cut you off from further comments on no waiver on the anti-deficiency statute. So feel free to address.
Well, it's one of the few times I can come into court and I can say this is ironclad. I should win and smile. Of course, I come into court and say that many times, but this time this is for real, and there's no hemming and hawing here. I've got a really strong position.
So, Mr. Edney, isn't this a case where the borrower had a substantial, significant history? They worked together, they had interaction, and let's say that the lender had reason to be concerned about the honesty or the integrity or however you want to define it, of the relationship. Would they be honest with each other? They do not have the right, I take it from what you're saying, to say, I've got to tighten this up. there's some stuff I've got to do here to ensure that we're both anteing up a sum that's going to hold each other's attention. Do you understand what I mean by that?
I think I do, although I think I would call I think my client is as honest as the day is long, and not just in the Casablanca sense, but in the real sense.
Saint. My
Yes,
question is, this is a commercial relationship, right? It's a
Yes.
lender-borrower relationship.
Yes.
And they had some problems in bankruptcy court. They had some problems, came out of bankruptcy court on terms,
Right.
all that. Did the lender have any right other than to track a piece of paper that has you can loan this much, you can take this much interest, you can extend it for this many months, is there no latitude, are the lenders that bound by this? Is one of the things they have to comply with, straight up, is the anti-deficiency language of the rule?
Oh, they had two paths to follow. The lender did. Thinking that, well, maybe there's some problems in the relationship, that Mike is financial stability is questionable. He's got a good heart, but maybe he won't be able to do this. So they had two paths. One is the trustee sale, which triggers the 33814G, which they tried to avoid. And the other path is a judicial foreclosure.
Right.
And there's no anti-deficiency that would apply in this particular situation if they had gone that direction. But they didn't. They decided to go with the 814G, that path.
And your client was given an option, right? We can either lend to you, and you waive the anti-deficiency entitlement, or we not waive.
He can't, but yes.
You're saying by statute he can't take the option.
He had no option. You can't say to a borrower, you can waive the 814G, because you can't waive it. At any stage, you simply cannot waive it. That's off the table. And since it was off the table, they tried this sideways approach. You know? It's like it's like the Japanese fleet approaching Midway. There's many ways to go.
Wasn't he still able to protest it? He was still able to, his counsel was there, and he was still able to push back against.
Mike was?
Yeah, at the hearing.
Well, at the deficiency hearing, the roof fell on him because there was nothing he could do. The trial judge said, well, this is an unusual arrangement, but you can't say anything to defend yourself, really. And his lawyer did a magnificent job at tap dancing, worthy of Chicago, but it didn't work. It couldn't work because there wasn't anything he could do really to defend. So my primary position is 814G is ironclad. You can't waive it on appeal. Can't waive it anywhere. The secondary one is the 814A was not waived, and that would provide another level of protection. I did have a discussion in the briefing about unconscionability and consideration. I'd just like to stand on the briefing. I did the best job I could with that during the briefing. I hope waiver doesn't apply to that, but I've had that brick thrown at me several times. If I may reserve the rest of my time?
Yes.
I'll give it back if I don't use it, I promise.
Okay.
You're not just going to stand at the podium until the clock runs.
Okay.
I've seen lawyers do that, or the equivalent.
Mr. McGrath, you just hold on just a second.
May it please the Court, Pernell McGuire and Corey Torgeson, Davis Miles McGuire Gardner on behalf of Ariel Funding. I'll pick up or start where Mr. Abney did, which is this issue of 33814G. At page 28 of Mr. Abney's brief, he cites the court to the case of Arizona Bank and Trust versus James R. Barron's Trust, 237 Arizona 401. And in that case, the Court of Appeals specifically held that the protections of 33814G can be prospectively waived by a guarantor. And I know we're dealing with a borrower in this case, but the argument that 33814G on its face specifically prohibits a waiver was explicitly rejected by the court in that case. Instead, what they did is they said, let's look at the policy reasons behind 33814G and see whether or not we should find that an implicit waiver can occur as to a guarantor. And of course did that analysis and made fairly short work of that and said a guarantor, the policy considerations regarding the protections of the anti-deficiency statutes just don't apply to a guarantor like they do a borrower. But that case is important for the proposition of does 33814G specifically prohibit a waiver? The answer is clearly no. So that does not then mean that the court cannot find an implied waiver in the statute. That's the next step of the analysis. And I think the court in the CSA Luke case, as Judge Brown referred to, gives us really the very best analysis in terms of figuring out whether or not a statute implicitly provides for waiver or not. In that case, the court said, so unless an otherwise identifiable public policy clearly outweighs the interest of upholding not only a contractual provision, but in this case, one contained in a settlement agreement, then the right can be waived. So they look at whether or not there's an identifiable public policy that outweighs the interest of upholding a validly negotiated contractual provision. In this particular case, the court, I'm sure, understands this, but I do want to reemphasize that this was a second lien home equity loan, non-purchase money, which means that my client always had the right to pursue a deficiency against Mr. Van Sickle. Always had that right.
Do we know that why? Because of Helvetica case, or because how do we know he didn't use those funds? I thought the Helvetica decision went into, which I was on, but it's been a few years. We discussed the home equity loan in that context, but it may have been under the other statute. However, I thought there was a breakdown, and the things that were not used to benefit the residents, in essence, could not be subject to protection of the anti-deficiency statute. But other investments in the home, that could be. Do we know what these funds were used for here? That's
a good question, Your Honor. Purchase money versus non-purchase money. It needs to be non-purchase money. There was never any evidence presented at the trial court that it was non-purchase money.
Okay.
That's just my understanding. I think institutionally I've lived with this case for so many years that in the bankruptcy proceedings that information came out, but I can't cite the court to the record right now that establishes that.
So we don't have to decide that issue, right?
Correct.
You're throwing that out as background.
Correct.
Okay.
But I think, Your Honor, that in the context of the settlement agreement, what my client wanted to do was preserve its rights to pursue a deficiency in the event there was a default under the settlement agreement. So this wasn't, again, as the court put it, trying to slide some specific language in there. This was a 2-year plus dispute between these parties that was heavily litigated both in the state court and the bankruptcy court, and then a settlement agreement was entered into with the intent, from my client's perspective, of ending all issues between the parties. My client was going to conduct a non-judicial foreclosure, and that was going to be the end of the story. But in the event, as Judge Jones indicated, in the event that Mr. Van Sickle violated the terms of the settlement agreement, my client wanted to preserve its rights to pursue a deficiency, which was its right prior to entering into the settlement agreement. It did not want to give that up in the event there was a default, and sure enough, that's exactly what happened. Mr. Van Sickle defaulted under the settlement agreement. That issue's not in dispute nor on appeal. He violated the terms of the settlement agreement, and so my client then had to incur additional costs, additional litigation, so it determined that it would pursue the deficiency, which under the settlement agreement we believed it was entitled to do.
Counsel, let me go back to the issue of waiver. First of all, are we obligated to decide the issue of whether the anti-deficiency statute can be waived? And being that it was not raised in the Superior Court.
Well, yeah, I mean, our position is that the court is not obligated to decide that we pointed out in our briefing, Your Honor, even constitutionally protected rights can be waived if they're not preserved in the trial court. And this case had an interesting journey through the Superior Court in that Judge Whitten allowed us to file motions for summary judgment and motions for reconsideration, and basically denied everything, but did say we had the right to pursue a deficiency. He granted our motion for summary judgment on the issue of whether or not there was a default under the settlement agreement. Our position was at that point, the case is over. Once there's a default, the settlement agreement says that Mr. Van Sickle can't defend against a deficiency proceeding. So we believe that that was case over, provide us with a deficiency. Judge Whitten then said, no, I'm still going to put you through your paces. You still have to come in and file a deficiency action and have a hearing. Through that entire process, the issues that are now being raised with respect to waiver of the anti-deficiency provisions, unconscionability, et cetera, were not raised, nor heard, nor tried in the trial court. So we believe they've been waived.
Was it your position then that that agreement encompassed, and if so, where in the agreement did it do this? Did it encompass Mr. Van Sickle's waiver of the right to have a fair market value determination?
Our interpretation, Your Honor, is that while it doesn't specifically mention the fair market valuation issue, that it does indicate that he would not defend in any deficiency proceeding. And a fair market value hearing is, the heart and soul of a defense to a deficiency action. It's where you come in and say, no, the property sold for more than the obligation, and therefore there is no deficiency. So that's a defense. I've done lots of those types of hearings, and that's one of the first things you look at in terms of a deficiency is what was the fair market value of the property at the time of the foreclosure. So,
what about Mr. Abbey's argument that it's just simply not in the agreement to that level of detail? And if we're talking about a known relinquishment, a voluntary relinquishment of a known right, how do you get to that point where you're? This is a weird situation to me because the court still allows a counsel to come in and argue parts of the case, but not other parts of the case. And it seems like a hybrid approach. But it seems to me you're saying, well, as to fair market value determination, that's all or nothing. There's nothing he could do about that once he's breached that settlement agreement.
Right. So to answer the court's first concern, I don't think the actual word waiver needs to be in the document itself at all. Waiver is a known relinquishment of a right. He knew that he was giving up this right. The other problem we have, though, Your Honor, but this is a problem that Mr. Van Sickle's counsel created, was that they never brought up this issue before the trial court so that we could then come in and cross-examine Mr. Van Sickle with respect to that very issue or argue whether or not it was a knowing relinquishment, that he knew what he was doing when he signed the document. But it kind of goes back to just contract interpretation, contract 101, that you're presumed that you have read the document that you signed and that you know its contents. And those contents of this settlement agreement clearly provide that my client would be free to bring a deficiency action and that Mr. Van Sickle would not bring up any defenses except performance under the agreement. He still had that as a fail-safe. Even under this agreement, he could come in and say, I didn't breach the settlement agreement, which he did contest, and the court, again, on summary judgment, ruled against him. And again, that issue's not here on appeal. Again, Your Honor, this I just want to reemphasize, my client would have much preferred not to have to continue to litigate with Mr. Van Sickle. My client was fully prepared to abide by the settlement agreement, foreclose on the property, as was their right, being owed over $200,000, and move on. But it wanted to preserve its rights in the event there was a breach of the settlement agreement, which occurred, and then that opened the door for reinstating its rights to pursue a deficiency, which it did under the statute. We believe that the public policy considerations that apply in the context of a borrower waiving its right to the protections that a lender never had originally are simply not applicable to the facts and circumstances of this case. Again, our position is our client always had the right to pursue a deficiency. It gave up that right, provided that Mr. Van Sickle perform under the settlement agreement, and then he breached. Under those circumstances, the public policy concerns that apply in the normal context of a waiver just aren't applicable here, and therefore there was a waiver. There is no overriding public policy concern. In fact, the public policy of enforcing negotiated agreements, and especially negotiated settlement agreements, far outweighs any other considerations. That's all I have, Your Honor, unless you have additional questions.
Thank you, counsel. Mr. Abney, give us 30 seconds.
Oh, yeah.
Give us 30 seconds. Yes, yeah. Thanks.
The epidemic doesn't kill us. I think the disinfectants will. Just 3 or 4 short points, I hope. Judge Brown asked a question, and I'll paraphrase because I cannot match his eloquence. Are we obligated to decide the issue of whether there can be waiver of the protections of ARS Section 33814G? Yes, I believe you are, in not just a precatory or a hortatory sense, but also in a mandatory sense. It's the big thing we're raising here is the 814 subpart G, and if it applies, the case ends, and we unravel all this, and the deficiency judgment goes away. The next point was that is ARS Section 33814A a defense to a deficiency proceeding? No, it's not. It's simply a procedure where you apply with the court and say, I'd like to have an actual determination of the fair market value of the property here, and then the court determines that and will issue an order crediting that amount. But it's not a defense. It's simply a procedure that you follow to make sure that everything's on the up and up and that there is indeed a fair market value determination at some point. My colleague across the aisle said that they always had a right to pursue a deficiency. No, they didn't. Not under 814 subpart G. They had no right to pursue a deficiency whatsoever. Now, if they had gone through judicial foreclosure, there's certain procedures or deficiencies there and all that other fun stuff. But a lot of lenders don't do that because there's so many more additional protections, and you've probably all gone through this as jurists. There's so many more protections when you're going through a judicial foreclosure. Times are a lot longer. Everything slows down. There's defenses of many kinds. So they chose not to do that. They chose to go through the side door and try to finesse 814G, and you can't do it. And I would, if there's no questions, I'd like to give my remaining time to the court.
Questions? Okay, counsel, thank you both for your helpful arguments this morning. The court will carefully consider these arguments and the briefs, and we'll take this matter under advisement and issue a decision in due course. The court is now adjourned.